So warm welcome to all of you to the Seven Islands Shipping Limited and Marex Maritime Legal Conference and Awards 2024, themed Navigating Maritime Legal Tides, Current Trends and Future Horizons. As you're all aware that this is the second edition of this Maritime Legal Conference, and we are delighted to gather maritime professionals, legal experts and industry leaders at this premier event, where we will explore the latest developments, challenges and innovations within the maritime legal sector. A few instructions before we begin the final proceedings, and I'm sure we all can take care of that. Please keep your cell phones on silent. Note important exits to this hall. And during tea breaks, you can bring in your tea and coffee inside so that you don't miss the important discussions. To give you a brief about the conference, Marex Media started this Maritime Legal Conference in 2022, taking into account maritime legal as a specialized body of knowledge, where the sector had its own share of challenges and developments. Today's Maritime Legal Conference is a crucial platform for discussing evolving issues to shipping law, port regulations, dispute resolution and international maritime treaties. This event provides an opportunity for networking, knowledge sharing and developing best practices in the maritime sector. If you are involved in maritime law or the shipping industry, this is the place you have to be today. We look forward to an engaging discussion, insightful presentations throughout the day, and towards the end of the day, during the evening, we would celebrate outstanding achievements in the maritime legal community. So thank you once again for joining us. May we deserve a big round of applause. Thank you, that's very kind of you. Today we are privileged to be joined by dignitaries who are well known and renowned in their own fields. We are privileged to be joined by our chief guest here today, Justice S.C. Gupte. He is a retired former judge of the Bombay High Court. A warm welcome to you, sir. May we have a big round of applause for sir. We have our guest of honor, Mrs. H.K. Joshi, former chairperson and managing director of the Shipping Corporation of India. I extend a very warm welcome to you, ma'am. Also, we are joined by our very own Captain Kapil Dev Behel. We fondly call him KD sir. He is the chairperson of the advisory board of the conference. We also extend a warm welcome to other advisory board members present here. And last but not the least, the captain of the Marex team, Captain Kamal Chadha, Managing Director, Marex Media. Welcome, sir. So to give a little brief about the captain of our ship, Captain Kamal Chadha, he has been in the maritime industry for over 5 decades now. He doesn't look that old. He is presently Managing Director of Marex Media Group, a company with varied global interests. A former Merchant Navy captain, he is a business study postgraduate from University of Plymouth, UK. He holds several important positions in the industry. He is the Goodwill Ambassador and Warden of Company of Master Mariners of India, CMMI, Founder Member and General Secretary of Maritime Trainers Guild, MTG, Founder Member and Mumbai Representative of Association of Maritime International Commercial Interest and Expertise, AMC, Trustee of Charm Charitable Trusts, which promotes traffic safety and driving etiquettes. He resides in Mumbai with his wife and 2 children and is a stay fit enthusiast. And he is actually the man behind 25 years of Marex. So this year we are celebrating our 25 years. So I request Captain Kamal Chadha to please come forward and deliver the welcome address.
Thank you, Radhika. I was just looking at the screen over there, and there's some strange picture over there with all our backs of our heads. So I thought this one looks a bit weird. Wonder whose head that is. And turns out it's mine. Ladies and gentlemen, esteemed delegates, honored guests, namaskar. On behalf of Maritime Media and our many esteemed contributors, it is my pleasure and honor to welcome you all to the second edition of the SISL-Marex International Maritime Legal Conference and Awards here in the shipping capital of South Asia. Since this is the second edition, I was going to say the name and then add an again over there. That comes from me having watched recently the movie called Singham Again. I hope all of you will go and watch that movie and enjoy the 3 hours of Singham. We are thrilled to host this pivotal event themed Navigating Maritime Legal Tides, Current Trends and Future Horizons. This conference serves as a premier platform for maritime legal professionals, industry leaders and policy makers to come together, share insights and help the fuller understanding of relevant maritime laws. As the maritime industry embarks on a transformative journey influenced by rapid technological advancements, a need for greater safety of shipboard operations, regulatory changes and environmental challenges, the demand for robust legal framework has never been more critical. Today we have gathered some of the brightest minds in the field of maritime law to discuss these pressing issues, explore innovative solutions and foster collaboration. Throughout our sessions, you will hear from distinguished panelists. There's one there, Captain Tandon. And speakers who will delve into a variety of topics from the impact of it. Hello? That's what Captain Tandon's entry does. From the impact of digital transformation to the evolving landscape of safety, compliance, and sustainability in maritime operations. We have designed this conference to not merely impart knowledge, but also to encourage meaningful dialogue and networking amongst participants. This event will also feature our esteemed awards ceremony, recognizing the outstanding contributions of individuals and organizations that have significantly advanced the maritime legal sector. These acknowledgements celebrate excellence, innovation, and dedication to the maritime community. We encourage each one of you to take full advantage of the discussions and networking opportunities over the course of this conference. Together, let us navigate the tides of maritime law and chart a course towards a brighter, more sustainable future. Thank you for joining us, and we look forward to an engaging and fruitful conference. Jai Bharat.
I said Namrata mentioned this to see, but I'm waiting now to see status.
Thank you, sir. I now request our esteemed dignitaries, Chief Guest Justice Gupte sir, our guest of honor Mrs. H.K. Joshi ma'am, Chairperson of Advisory Board Captain Kapil Dev Behel and Captain Kamal Chadda to join us for lighting of lamp.
तत्पुरुषाय विद्महे वक्रतुण्डाय धीमहि तन्नो दन्ती प्रचोदयातु। तत्पुरुषाय विद्महे वक्रतुण्डाय धीमहि तन्नो दन्ती प्रचोदयातु। तत्पुरुषाय विद्महे वक्रतुण्डाय धीमहि तन्नो दन्ती प्रचोदयातु।
May I request all the dignitaries to please join us back on stage. This beautiful lamp here represents the themes of enlightenment, hope, purity, and triumph of light over darkness. It also embodies faith in knowledge. May I request Captain Behel to join us on stage. Thank you. We are privileged to have amongst us our guest of honor for today, Mrs. H.K. Joshi, former chairperson of Shipping Corporation of India. She is a highly accomplished leader with extensive experience in maritime and energy sectors. She is the former chairperson and managing director of Shipping Corporation of India, SCI, where she also served as a director of finance. Prior to her tenure at SCI, she was the general manager at Oil and Natural Gas Corporation Limited and headed the finance at ONGC Videsh Limited. During her illustrious career, she played a pivotal role in some significant milestones, including leading the largest overseas investment by an Indian PSU and turning around SCI from a loss-making entity to a profit-making one. She also led SCI through the challenges of COVID-19 pandemic, achieving record-breaking performance. Her leadership has earned her numerous accolades, including the Maritime Standard Personality of the Year 2021, the CMD Leadership Award at the 8th PSU Awards of Governance in 2020, and the Best CMA CFO Award from the Institute of Cost Accountants of India in both 2014 and 19. She is also a fellow member of Institute of Cost Accountants. She is a lifetime member of Institute of Public Administration and member of Institute of Directors. She has been an active member of the Finance Committee of Indian Maritime University and draws inspiration from many individuals, believing in learning from everyone. She also looks up to figures such as Warren Buffett and Ratan Tata for their leadership and wisdom. Outside her professional achievements, she is passionate about animal welfare, teaching gardening, and practicing yoga. She lives by the words of Henry Todd, "The cost of inaction is vast. Don't go to your grave with your best work inside you. Choose to die empty." So we have an luminary amongst us, and I request Joshi ma'am to please share her thoughts with our audience. Thank you, ma'am.
Chief guest of today's event, Justice Gupte,
the board of advisors of the event today, and particularly the chairperson of the board of advisors, Captain K.T. Behel, and MD of Marex Media, Captain Kamal Chandra, esteemed guests, learned panelists, ladies and gentlemen. It's indeed a pleasure for me to be standing here and addressing you on the second edition of Marex on the legal platform. Incidentally, I happen to have been a part of it in 2022, and it's a privilege to be back here with you all in 2024. Maritime legal issues are critical and important, as I'm sure the learned audience knows, both in India and globally. The world's oceans and waterways are not just a source of natural resource, but as we all from the maritime industry know, these are the critical trade routes. And maritime law governs all activities that take place on the sea, and its importance therefore cannot be overstated. From environmental protection to maritime safety, commercial shipping, piracy and territorial disputes, the legal landscape is vast and complex. And needless to say that all of such disputes have a financial bearing, and which explains my presence here today as a person from the financial domain, because you couldn't have settled a legal dispute without financial implication. Today's Maritime Legal Conference, as has been said, is the second edition, and in today's conference, the agenda, which has been very knowledgeably drawn out by the Board of Advisors, is well thought of, and many important concerns will be deliberated, and I'm sure there shall be several learnings and various takeaways for all of us over here. Maritime legal issues are multifaceted and quite complex, and they become even more complex as the seas are international and do not belong to any one particular country or jurisdiction. Multiple jurisdictions therefore come into play. From piracy and environmental protection to territorial disputes and shipping safety, the challenges that we are facing now are not national in scope but have become global. India, with its strategic location and growing maritime interests, has an important role to play in the global maritime legal landscape. However, addressing these challenges requires cooperation, stronger enforcement, mechanisms and adaptation to new technological realities. As India continues to develop its maritime sector and increase its influence in global shipping, trade and maritime security, there are several key areas where India's maritime legal framework would require improvement and adaptation for the future and make our presence in the global sphere in this area as well. Our maritime legal framework could address current challenges and position the country as a leader in maritime governance globally. I think this is a dream which is achievable, and we all need to work towards it. As the world becomes more interconnected through maritime trade, our legal systems must evolve to meet these challenges. By doing so, we will ensure that the oceans remain a safe, sustainable and accessible resource for future generations. Through today's conference, we shall be deliberating on such concerns and attempt to find suitable solutions. I wish Marex another fruitful and successful conference along with Seven Islands Maritime Training Institute, and each of you present today, I am sure, shall benefit and gain from the deliberations. Wishing a great success to the conference. Thank you so much. Thank you, ma'am. I now request Captain Kamal Chadha to please come forward and introduce our audience to our chief guest, Justice S.C. Gupta ji.
Thank you so much, Radhika. Justice Gupta has an illustrious academic and legal career. He completed his graduation in arts from Ruia College, Mumbai, followed by a post-graduation in philosophy from the University of Mumbai. He earned his LLB from New Law College, Mumbai in 1981. Justice Gupta began his legal practice in 1981 before the Bombay High Court, where he worked on both the original and appellate sides, specializing in constitutional law, commercial law, company law, indirect taxation, and arbitration. His practice also extended to the Honorable Supreme Court of India, various high courts, district courts, and tribunals across the country. In 2013, Justice Gupta was appointed as an additional judge of the Bombay High Court, serving in that capacity until 2015, after which he was appointed as a permanent judge of the court. During his tenure, which lasted until his retirement in June 2021, okay, not very far back, he was notably appointed as the first judge of the Commercial Division of the Bombay High Court. As a judge in the Commercial Division, Justice Gupta adjudicated several significant admiralty cases, including the Murmansk shipping case, which involved important issues related to the constitution of limitation funds, and the Pacific Gulf Shipping Singapore case, which dealt with the arrest of cargo. His tenure was also marked by numerous landmark decisions in constitutional, commercial, taxation, and industrial law, such as the ruling that struck down the state's ban on the possession and consumption of beef, the PILs in Harit Vasai Saurakshan Samiti that addressed the demolition of illegal constructions, and the Petrol Dealers Association case, which led to the setting aside of Maharashtra's licensing and control order. Additionally, in the NSEL investors case, Justice Gupta ordered a forensic audit and a liquidation of assets of defaulting borrowers. Following his retirement, Justice Gupta has continued to contribute to the legal field as an arbitrator in commercial disputes. He has presided over numerous arbitration cases and regularly lectures on commercial law, including at institutions such as the Indian Merchant Chamber of Commerce and Industry. In 2022, he was invited to deliver the prestigious Bansiri Seth Memorial Lecture at the Asiatic Society in Mumbai. He has also contributed an article to the Principle of Competence in Arbitration Law to the Compendium of Arbitration Law in India, published by Oxford University Press. Beyond his professional engagements, Justice Gupta offers expert legal advice and opinions on various commercial and civil matters, further solidifying his reputation as a respected figure in the legal community. Please welcome Justice Gupta.
Good afternoon, friends. I am happy to be a part of this important event. Admiralty law, as anyone would say, has a very special place in the jurisprudence of all seafaring nations. Its importance from the global economic point of view can be gauged by the fact that nearly 90% of global trade by volume takes place through maritime trade, and a whopping $380 billion is added to the world economy through maritime trade alone. So naturally, the Admiralty law, one would have thought, would be an important area of Indian jurisprudence, since India, as the 16th largest maritime trading country, with a coastline of about 7,500 plus kilometers, having 12 major and 217 not major, other than major ports. But alas, it ought to surprise us that our law has always been, and I dare say even today is, out of pace with the maritime jurisprudence generally of all seafaring nations. And this despite the fact that we have been one of the earliest maritime trading countries. Even our Rigveda talks about maritime trade with distant islands through sea. The travesty of the situation can be gauged by the fact that as late as 1992, when the Supreme Court delivered its momentous decision in MV Elizabeth, we were actually following English Admiralty law, which was more than 100 years old as of 1992. But that's the travesty of the situation. In Britain, of course, the foremost seafaring power, maritime law took roots in the 18th and 19th centuries. The initial legal principles established by the Admiralty courts in England found their expression in the first important English statute, which was the Admiralty Act of 1840, which was followed by a more comprehensive Admiralty Courts Act of 1861. Now, under this later act, the English courts assumed the jurisdiction in respect of all claims relating to cargo carried into any port in England or Wales. So the entire gamut of claims in respect of cargo, which is an inward bound cargo in England or Wales, was under the purview of the English Admiralty courts, but that also meant that the outward bound cargo was beyond its jurisdiction. This anomaly was done away with in England by the statute known as the Administration of Justice Act 1920, and it extended the jurisdiction of the High Court in respect of all claims arising out of agreements for use or hire of ships, as well as all contractual or tortious claims pertaining to carriage of goods by ship. So, in other words, it did away with the dichotomy of inward and outward bound cargoes. But unfortunately, as we have noted just now, the jurisdiction concerning outward cargo was not available to Indian courts even as of 1992, because we did not have the benefit of all subsequent English judgments. So on 8 February 1984, when the vessel MV Elizabeth, a foreign registered vessel, which was lying in the port of Marmagao, left the port without issuing any bills of trading or other documents of title to the goods as required by the plaintiff shipper, the goods were discharged to a consignee at the port in UAE without his having paid for these goods the agreed price, and this despite the plaintiff shipper's instructions. So when the ship was returning from its voyage and it entered the port of Visakhapatnam, the plaintiff caused its arrest through a suit filed in the Admiralty jurisdiction of Andhra Pradesh High Court. The owner entered appearance, he posted security in protest, and then went to the court and challenged the court's jurisdiction. He said this is a claim in respect of carriage of outward bound cargo from a port in India to a foreign port, and as Admiralty Court, Andhra Pradesh High Court would not have jurisdiction, because its jurisdiction is restricted to the jurisdiction exercised by English courts in 1890. So in other words, our court's jurisdiction was treated as frozen as of 1890. And in one of its one of the finest hours of Supreme Court, it negated this contention. It said that the Admiralty Courts Act of 1890 is not a statute of limitation of power. It is in fact an enabling act. In fact, it encompasses Admiralty jurisdiction of the High Court, whether existing by any statute or otherwise. So in other words, whichever sources the English courts have developed their jurisdiction, Admiralty jurisdiction out of, all those are available to Indian courts. And in fact, this Admiralty jurisdiction, the court said, was an essential aspect of judicial sovereignty. And under the Constitution, as a superior court, as a court of record, High Court administering justice had power to enforce claims against foreign ships which came within its jurisdiction. That was a momentous decision which changed the course of Indian maritime jurisprudence. So the MV Elizabeth case was followed by the 51st report of Indian Law Commission. The Law Commission suo motu took up this issue on the basis of observations made by the Supreme Court in the MV Elizabeth case. The Law Commission ruled the fact that we did not have till then our own Admiralty law, and it then proposed a comprehensive enactment, legislation, draft legislation on Admiralty jurisdiction, and this was to meet the pressing and long-standing needs of our industry. Though the Law Commission made its recommendation in 1994, the legislation had to await next 23 years, and finally it came in the form of the 2017 Admiralty Act. This act made, of course, significant advancements in our legal framework pertaining to maritime claims. It outlines the scope of Admiralty jurisdiction of the High Courts instead of the original 3 chartered High Courts, which alone had Admiralty jurisdiction till then. It conferred such jurisdiction on all High Courts of coastal states in India. It outlined maritime claims. It described maritime lien. It provided for Admiralty jurisdiction both in rem and in personam, as you know, of the High Courts. The inter se priority of maritime claims, of maritime lien, and protection of all owners, charterers, etc. So a comprehensive law on jurisdiction. Though again, by means of this enactment of 2017, though we have come a long way in our Admiralty jurisdiction, it's still not long enough to keep pace with other seafaring nations. And now it is important in that context for us to note, as a kind of a beginning, I would like to make a beginning. You will be taking note of various other issues, etc. But since this is focused on the existing Admiralty law, let us note these. In the first place, the 2017 Act, as its title suggests, is relating to the jurisdiction. That jurisdiction needs to be exercised with the help of appropriate rules, forms which are suitable in the Indian context. And unfortunately, we still do not have any central government made rules for the practice and procedure of Admiralty. Of course, for costs, expenses, everything, all ancillaries, incidental matters. Of course, this Code of Civil Procedure does apply to the extent it is not inconsistent with the Act of 2017. But then the code does not itself have any provisions of particularly relating to Admiralty practice. So we had to rely on the Admiralty rules framed by the 3 individual chartered high courts. Even the other coastal high courts still don't have their rules. So there is no uniformity, there is no certainty. In fact, when I delivered my judgment in the case of Murmansk shipping, which related to Constitution of Limitation Fund, and which was an important subject from the point of view of protection of ship owners, we found that there was a complete lack of rules relating to practice, procedure and forms. In fact, we had to devise our own procedure, keeping in mind the general procedural provisions, common sense, and taking help wherever possible from the English Admiralty practice. So that was there is an imperative need for us to frame a central delegated legislation pertaining to practice, procedure and forms relating to Admiralty. Apart from practice and procedure, even as a substantive law, there have been quite a few gaps in the Admiralty Act of 2017. For example, the Act does not have any provision for arrest of ship or cargo for security pending arbitration. In fact, there are provisions in Article 2, 3 and 7 of the Convention of 1999, the International Convention of Arrest, which provide for security arrest pending arbitration. We do not have this provision. Now it is left to our courts to devise or to take a call on whether an action in rem would lie to obtain security when the dispute between the parties is the subject matter of an arbitration. Fortunately, Bombay High Court in the case of CMCN Offshore Reddery versus Aldous Huber, a case where the subject matter concerned arrest of a ship pending arbitration, it held that an action in rem for recovery of a claim and arrest of a vessel, whether parties have agreed to submit their dispute to arbitration, does lie. And this decision was used even by Calcutta High Court and an arrest was ordered. So, though the courts have supplied these gaps, we still need statute for jurisdictional certainty, because there are different court, different arguments are advanced, and why should this be a subject matter of debate in a court of law? It's a very common subject. So the legislature shall do well to supply these gaps and supply this infirmity. Another instance I would like to point out is the all-important aspect of Admiralty jurisdiction, namely the arrest itself. Whereas Article 4 of the 1999 Convention has an appropriate provision for release of a ship from arrest upon deposit of security, we don't have such a provision in law. We still have to, the ship owner has to fall back on the inherent jurisdiction of our courts to seek release of a ship by posting a security. Not necessarily a good way to go about in a routine matter like arrest of and release of ships. In fact, the Convention of 1999 has very specific provisions relating to security. For example, what if this security is, the person may apply for offering a security to have that security reduced, modified or varied. There is no provision in our law. So also if the security for any reason falls short or is inadequate to unlikely to fulfill any or all of the obligations of the ship owner, then there is no provision of re-arrest, multiple arrests and increase in security value, etc. So we'll have to apply every time to the court to invoke its inherent jurisdiction, which it has always exercised in keeping with the latest international standards. Yet another aspect concerns maritime liens versus maritime claims. The 1999 Convention defines maritime claims extensively, and it is more or less adopted in our Act of 2017 in Section 4. But unlike the convention which keeps out of this maritime lien business, the Act describes maritime lien as an instance of maritime claims. Now it's a very strange kind of arrangement. Whereas all maritime liens are set out, described in section 9, when they talk about the priority in maritime liens. In the maritime claims, all those are set out, albeit in different phraseology. And at the end, there is a statement that even a maritime lien will be a maritime claim. Now, this kind of arrangement introduces a lot of uncertainty, a lot of scope for judicial debate, and it takes inordinate time of our courts to rule on these subjects. It should be a very clear provision. So all of these important issues need to be addressed. In fact, the shipping community and all stakeholders gathered here today would have to address these important issues, besides of course several other issues which you are going to discuss in today's conference, and work towards a forward path. Now friends, it is nice that the organizers of this conference have taken an initiative and to address various concerns afflicting the industry. I commend them for it and extend my best wishes to all participants. Thank you.
Thank you, sir, for bringing forth so elaborately the gaps in admiralty law and suggest relevant measures. Thank you very much. I now request Captain Kamal Chadha to present a small token of our appreciation to the dignitaries present here. To our chief guest, Justice Gordon. Thank you, sir. The Maritime Icon 2024 coffee table book consisting of 100 important people from the maritime industry, published by Marex Media. I request Sir to felicitate our guest of honor, Mrs. H.K. Joshi ma'am. Gratitude for the chairperson of Board of Advisors, Captain Kapil Dev Beher. Thank you, sir. Your support has been